Travis Wingoodsill. While listening to Ari Melber's show, he had a guest that brought up Federal Rule number 11. And as I'm looking over it, I'm realizing that I'm more protected than the federal court is wanting me to be. This is for representations to the court, whether it's a pleading, a motion, or other papers. So my initial complaint, the subsequent motions by both the defendant and myself, and my briefs that I've been submitting, which would be considered as other papers, are involved here. It also includes sanctions, and this involves Judge Campbell and what she wrongfully did, according to Rule 11. The first part, A, is about the signatures, and there's no need to worry about that one. But B, representations to the court. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of their knowledge, the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, 1, it is not being presented for an improper purpose, such as to harass, cause unnecessary delay, and or needlessly increase the cost of litigation. The defense counsel, in submitting their rushed motion this time around, did so with an improper purpose, as this further goes into, to not only harass, but needlessly increase the cost of litigation for me, as I've had to do other things that have required the expenditure of money, though minimal in their eyes. 2, the claims, defenses, and other legal contentions are warranted by existing law or by non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. So, yeah, that gives me a lot of latitude if I can show the argument for it. It's not just an existing law that I have to adhere to, which is what the federal courts have been trying to drill into me, as they keep quoting existing law to justify violating my First Amendment right to petition. And then 3, factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. This is where they get busted, because the defense counsel keeps claiming I don't have a claim upon which relief can be granted. They demand to see the evidence. They call my complaint a conspiracy theory, which is an incorrect definition, as I've been informing you. But they're trying to dismiss my case to deny number 3 here. And so, yeah, well, we'll get to that when we get to sanctions next. And then denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on belief or a lack of information. And that's what they're trying to claim, but I haven't presented evidence they're trying to claim that it's on the surface, on the evidence of the factual. Yeah, well, they lose because I've got the evidence. Alright, so let's get out of that program. The other one I had to mute to do this video. Sanctions. In general, if after notice, see, the Judge Campbell did not give notice. What she has done is ordered that I no longer be allowed to motion or submit other representations, the briefs, to the court. She has sanctioned me. And she didn't give advance notice. She just did it. And the clerks, went along with it. You can see it on the docket that the court clerks refer to her ruling, her order, and yeah, it silenced me. Even though you see my motion for her recusal, you don't see what it is because the clerks say that her order overrules it. And my attempt to go through the chief judge was also denied. And so I can't even bring up a new motion for this additional information of what she's done, as it's going on 2-3 weeks now and still nothing. We'll see if she did something today or if she does something this week before the Thanksgiving week. It's not looking good for me, but as you can see, they're purposely violating the law to protect the church. And so on the court's initiative, on its own, the court may order to show cause why conduct specifically described in the order was not violated. The nature of the sanction, a sanction imposed under this rule must be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. And she didn't give prior indication that I was doing something wrong. She immediately was assigned, immediately called my motion to recuse Judge Jenkins as moot, which disqualifies all of the information contained in it and denies that it was his recusal was in response to my motion. And so she can't do that. And so I put in a motion to say, no, you can't do that. And I got shut down as punishment without prior notification. And so an order to the sanction may include non-monetary directives, an order to pay a penalty into court, or if imposed on motion and warranted for effective deterrence, an order directing payment to a movement of part or all of the responsible attorney's fees and blah blah blah. And so that doesn't apply, because her sanction was that neither of us can motion until she decides on the other motions. And the first on that list that she put was the defense counsel's motion to dismiss the original complaint, which was dismissed by Judge Jenkins, who ordered me to amend it, of which I did but the church did not respond to the amended complaint, as I put in a motion, but now. And so their claim to, I can't remember which rule it was, Rule 8 or 15 or whatever, had to do with the filing procedures. And they were claiming that I was violating that particular rule, but I'm following the pro se litigant guide, which is the federal court official procedures for civil proceedings for a pro se litigant, of which I am, and they're saying that it's wrong. The guide is wrong. And so I argued that that's what they're claiming, and that the judge, Waddups, in the previous lawsuit, of which he now gets brought into this one, because this is a different complaint, and then thus Judge Jenkins, for his dismissal, as he's trying to claim that it was the same situation, they're both wrong in violating the law because I'm following the pro se litigant guide. And it was approved. Both of them were approved as a legitimate complaint. And so they don't have cause to dismiss on the defense counsel's motion. And so, yeah, I've got a clear-cut case of obstruction of justice by the justices. And so now I have a law that puts into words what I've been complaining about this whole time. But I can't do anything about it because I've been sanctioned with the punishment of censorship. So, this week we start again checking after midnight every day to see if the judge has finally ruled on something. But it's set up so that I can't do a preventative measure anymore. Because my motion for her to recuse has been denied being put on the docket until she decides these other three motions, of which she can't because she needs to recuse herself. And she's obviously not recusing herself. And so, yeah, she thinks she's got me caught in a catch-22, but it's her that did it. It's not an actual catch-22. That's where circumstances independent of human action led to the conflict dilemma. Though I'm sure the movie probably had something slightly different on that respect. But this is a premeditated, underhanded tactic by Judge Campbell. So it doesn't get considered as a catch-22 when she's the cause of it, knowingly and premeditatively. But this case involves the church using a viral weapon to tamper in the lawsuits and to destroy me, to murder me. And it's a legitimate complaint, and it has merit, as each and every single day demonstrates how I am right with this petition and how they are guilty, and that my request for relief must be granted. So that's an update, but it's sad that there's so much corruption. Moved it down too low.